Hey folks, Ben Wittes here. Welcome to this week's Trump Trials and Tribulations from the Hammock Studio. I'm joined by Roger Parloff in the Scott Studio and Anna Bauer in the doctor's waiting room of her palatial mansion. And everybody else is distracted, like there's an election going on. They think there's war in the Middle East. Not us. We are focused like a laser beam on Trump's trials and tribulations, because while you have been reloading the latest 538 election average every 20 minutes, yes, there has actually been action in all of the trials in which Trump has been tribulating, and we have been following it undeterred by everything else that may be going on in the world. So where should we start, guys? Should we start in Georgia? I think we're going to start in Georgia, where that case may be in its final phase of disintegration. And so I'm just going to start, Anna, with you. Is the Fulton County case finally collapsing in a sinkhole of despair? What has been going on there this past week?
Well, no, I don't think that it's collapsing into a sinkhole of despair, but certainly I think that this was yet another blow to the prosecution. Keep in mind, there's still, it was a partial victory in the sense that the judge declined to throw out the entire indictment, declined
so wait,
to
back up and tell us what happened.
Right. Okay. So there was some breaking news this week, or excuse me, I guess it was, yes, it was earlier this week, correct? Or am I blurring my weeks together? There was breaking news earlier this week when Judge Scott McAfee, also known as Boy Wonder, issued an order, which was a bit surprising to some folks, because it has been the case for several months now that most of that prosecution has been on pause. However, there are at least two defendants who do not have a stay on the case as the other defendants litigate the disqualification of Fani Willis at the Court of Appeals. That is John Eastman and Sean Still. They did not ask for a stay. They are not a part of that appeal that's ongoing. And so Judge McAfee issued an order related to their cases in which he threw out three of the counts from the Trump indictment. Technically, it is not yet the case that those counts have been thrown out as against all the people who have their Court of Appeals ongoing litigation, because the case against them is stayed. So Judge McAfee doesn't have jurisdiction to throw out those charges as they apply against them. But there are a number of other people who do have an ongoing appeal at the Georgia Court of Appeals who will be affected when that case goes back to Judge McAfee. People like Trump, people like Rudy Giuliani, Kathy Latham, a number of those defendants will be impacted by this. But for now, it just impacts Sean Still and John Eastman. It's three counts from the indictment that were thrown out. Each of them relate to false statements or false filings. And as they relate to the fake elector scheme, and we can get into a little bit more into the reasoning, but as I was saying previously, there's a bit of a partial victory here in that the entire indictment wasn't thrown out. It is just three counts. And keep in mind, this is an indictment that involves it's a very sprawling case. So there's still plenty of other stuff in there. But I certainly do think that, as we've discussed on the show, I mean, things are not going well for the Fulton County prosecution. And it seems like this is yet another blow to that prosecution.
Okay, I want to ask you about the larger state of the prosecution, but before we do, tell us about the basis for this opinion. What is the rationale for the dismissal of these 3 counts?
Right. So this arose within a larger argument about the preemption that could be under the Electoral Count Act. We had Ken Chesbro's attorneys on last fall to discuss their argument on this issue. There's this argument that some of the defendants have been making. It's very similar to that argument that we discussed on the podcast, in which they argued basically that the Electoral Count Act preempts this state prosecution of the fake elector scheme, basically saying that the state doesn't have jurisdiction to prosecute this because it's a fully federal issue. So spinning out from that argument is this very specific briefing that occurred on a specific case that the Supreme Court entertained in the 1800s called In Re Loney. And in the context of that case, the Supreme Court back in the 1800s essentially said that when a witness is testifying before a purely federal tribunal, they can't then be charged with perjury under state law, because the kind of interest of justice, like, basically is exclusive to the federal government as opposed to the state government. And so the defendants found this case, raised this specific issue, saying that these specific charges that relate to the fake electors, things like filing false documents in federal court, sending the certificates of the electors to a district court, things like that, they argued are therefore not subject to the jurisdiction of the state of Georgia. If there's going to be a prosecution of those issues, it has to be through the federal government. So there was a series of briefing on this. Judge McAfee, in the order, denied the kind of overall overarching preemption claims about the Electoral Count Act, in which they argued everything needs to be thrown out. But there were these 3 counts, count 27, count 14, and 15, in which he said, yeah, I think that In Re Loney should apply here. The easiest one for Judge McAfee to decide here, I think, was count 27. That relates to charges that for knowingly and unwillingly filing a material, false, fictitious, or fraudulent statement or representation in a Georgia court or a court of the United States. The specific document here that was filed was in that Trump versus Kemp case, in which John Eastman and Trump had some, they attested to various false claims related to the election. And Judge McAfee said, well, this would come within the federal perjury statute. And I think that therefore In Re Loney applies. It's in a federal court. The perjury laws would apply. And so therefore In Re Loney applies. There's no state interest. Throw this out. And then the other counts relate to hold on, let me pull up really quickly the actual indictment, but the other counts relate to the certificates that were submitted in relation to the fake electors. And those, McAfee says, would actually not. So, oh gosh, I could read off the list here, but it's a lot of people that it actually applies to. But it's conspiracy to commit filing false documents. It's the certificate of the votes of the 2020 electors from Georgia. And those were filed to the U.S. District Court in the Northern District of Georgia, to the chief judge there. And so Judge McAfee says, well, this actually has a little bit of a different analysis, because it actually would not fall underneath the perjury statutes of the federal government. And so I need to decide whether or not, there's concurrent jurisdiction here. He ultimately decides, though, that he thinks that because they were only submitted to a federal body, basically, And that is kind of the gist of the crime, was submitting it to that federal body, that there's not a state interest really in prosecuting this in the same way that there wasn't in Loney. And so therefore he said the same reasoning applies. So we got to throw out count 14 and 15. He did, however, keep in a number of other things related to the fake electors plot, things like forgery, which is different because it doesn't necessarily relate to the actual submission to a federal body, right? The crime is differently constituted. And so therefore those things are still in as it relates to the fake electors. But the ultimate thing is that these 3 counts are out.
All right. So I want to look at this for a moment from Donald Trump's point of view, which is, I have a chance before the Georgia Court of Appeals and then the Georgia Supreme Court to screw up the whole case by getting her disqualified again. That's the if I lose at both of those levels, a bunch of the counts are gone now. And among the, I don't remember how many will be left against Trump, I still get to go through the same process that I'm going through with Tanya Chutkin of saying you have to strike, sentence 8, sentence 9, and argue about where my presidential immunity applies. So it seems to me like Trump gets now a lot of shots at the barrel at this case in a way that he does not get in DC, where, there's no did Jack Smith pay for his vacations in cash with the girlfriend or boyfriend, whatever, who he was employing, question before the Supreme Court and DC Circuit. And, it just seems like the layers and layers and layers of problems in this case is really starting to catch up with the prosecution. Talk me out of the sinkhole of despair.
I mean, I'm not entirely sure how to talk you out of the sinkhole of despair, in that I agree with you. I will say that, look, as soon as that case was put on pause, it was always going to be the case that this wasn't going to happen before the election, and that everything would come down to whether or not Donald Trump is continued to be tried, comes down to the question of whether he wins the election. So there is nothing changed in that respect. I think too that in terms of this case, something else to keep in mind is that even though these counts are being thrown out or will be thrown out as it applies to Trump, they still have this conduct kept in as overt acts. Judge McAfee specifically rejected the idea that the overt acts, remember that's how a RICO prosecution works, is that you have this alleged conspiracy. There are certain acts that were committed in furtherance of the conspiracy. And so they still can kind of prove up some of this conduct in terms of showing the RICO conspiracy, and that is still the most serious charge against Trump that remains intact in this indictment.
It's true, although the overt acts presumably cannot be acts for which presidential immunity would apply. And so, I mean, those can't be, if they can't be evidence in the federal case, it's not clear to me why they could be overt acts in a state case.
Right. Well, I mean, there's things like, for example, the filing of the Trump versus Kemp. I mean, Trump was filing that as a candidate, not as a presidential candidate. So I think that is important. As in terms of the electoral certificates, I think that also seems to suggest candidate as opposed to president, but I'm sure that they will make some kind of argument to the contrary. But Ben, I mean, look, this case, I agree with you. Like it will be years I will be like that meme of the old lady on the Titanic where she's like, it's been 84 years by the time this case is tried. So I will say though,
Resistance wine grandma.
yeah, I'll be a resistance wine grandma by the time this case is tried. But you know, there are people like John Eastman who does not have a case that is stayed and who does not have the benefit of presidential immunity as far as we understand the Supreme Court's immunity ruling, because even though I think that it's very likely that people who were subordinates of Trump, and again, John Eastman wasn't a White House federal employee. He was someone who was an attorney working on Trump's campaign, basically. So I think that there are ways in which if this case is severed out, we could see trials of other people. And the question then is just, you know, like, to what extent do courts rule that the presidential immunity evidentiary privileges might apply to those people? To what extent, you know, to what extent do people see other people besides Trump being held accountable, meaningful in some way? And then, you know, what the timeline is. I truly, it's unclear to me right now exactly what the timeline is for a lot of these other people, especially someone like John Eastman.
All right. Meanwhile, elsewhere in Georgia, the chef's kiss perfectly named Mr. Scandalakis, which is Greek for he who manages scandals, made a long belated decision. Roger, who is he and what did he decide? Oop, you're muted.
Early on, and Anna can correct me on some of this, but there had been the Lieutenant Governor Burt Jones had been of Georgia had been under scrutiny for when he was a senator and was one of the false electors, and he successfully got severed out, and he was entitled to he won the right to have a different prosecutor because Fani Willis had I don't remember the details, but she had
attended a fundraiser for
she threw a fundraiser for his political opponent while she was investigating him.
Yeah. And so he finally did a report, and he seems to have viewed all of the grand jury evidence and a good bit more, and spoke to Jones, had 3 interviews, said he was cooperative. Basically, the charge seems would have been the false elector charges, and he was impressed that sort of the advice of counsel defense seemed to convince him that that he had been given advice that this was similar enough to the situation in Hawaii in 1960. I think most of our followers know about that at this point. That and his understanding was that that this alternate elector slate would be used in the event only if there were a live legal proceeding, and it was possible that a judge would find the fraud in the election, and then you would have this alternate slate. He said that he was impressed with that he had received legal advice, and also that legal scholars who he didn't name had also told him that this was uh, kosher to do what he was doing. I hope it was some legal scholars other than just John Eastman or Ken Chesbrough.
Well, it was all the legal scholars, all of whom wanted Roe v. Wade overturned, right? Of
Yeah,
course,
I guess so.
100% of them.
Yeah. There was another factual thing that sort of counted in his favor, which was that apparently the head of the Georgia Senate Judiciary Committee gave him a letter which he hoped he would deliver to Pence on January 5th, 2021. He was seeing Pence, Jones on January 5th, and Pence decided not to hand it over. I guess it was a letter to ask Pence to delay the certification for 12 days. And he thought better of going through with that. So I think what he wrote was, one of the things he wrote, for instance, was the evidence reveals Senator Jones acted in a manner consistent with his position representing the concerns of his constituents and in reliance upon the advice of attorneys when he served as an alternate elector. The evidence also indicates Senator Jones did not act with criminal intent, which is an essential element of committing any crime. There was a rendition of the facts, which maybe Anna can give you more detail, that was highly sympathetic and to sort of, if all you knew about this dispute came from Fox News, there were a lot of people thought there had been election fraud, and he was one of those people, and there's sort of something frustrating about that. There's a circularity of thinking, but I have to say, even Jack Smith was clear in the federal indictment that he thought a lot of the fake electors were innocent. They were dupes. They were told. And so I don't know what the story was, the facts were with Georgia, but, and I also, at this point, don't have a lot of faith in Fani Willis's judgment or Nathan Wade's. So, when thinking about if this is eventually going to get to a jury, and as Anna says, I might not get to the promised land with you. It could be a ways off. But if it does, I don't see how you necessarily win this case unless there's a lot of facts, because there is going to be evidence that lawyers were telling them this is the thing to do. And so I don't know how she gets over that hurdle.
All right, so
I think this is a disturbing development. Anyway.
So, Anna, one of the things that surprised me about this is that I did not understand Mr. Scandalakis as having the authority to resolve this case himself. I thought that when a prosecutor is disqualified, Scandalakis decides whom else to assign it to, not that I'm not going to assign it to anybody because I decide that the case has no merit. Am I misunderstanding his role?
Well, you're missing one step, which is that he waited 20-something months and then appointed himself to investigate the case.
Oh, I did miss that.
Yeah.
step.
So
This was sort of like the Dick Cheney thing where he had a committee on who would make a good vice president and decide.
And look, I got to say, Pete Scandalakis is a well-respected attorney. But I think it's always been the case that all the signs were pointing towards he seemed to have he was not particularly motivated to get this case into the hands of someone quickly. It, has never really seemed like this was going to go anywhere once it was out of Fani Willis's hands. So this isn't so much of a surprise, but as Roger mentioned, I mean, some of the ways that he describes the facts here, I found to be really, skewed in the direction of favoring an alternative reality that does not really seem like it gives a full kind of picture of what actually happened here. Like there are things and there are little things, but things that really stand out, like where he describes all of the cases being dismissed against Trump for lack of standing, which is a thing that people who,
That Trump says in the debates.
He says all the time that, oh, well, those were just, we never could get a real hearing. And so we had to do all of this because it was but it's like, well, that is how election contests work. It's things like that. And then also things like where he describes Robert Sinner's email in which Robert Sinners is saying we need complete and total secrecy. And he describes an interview or testimony of Robert Sinners in which Robert Sinners says something to the effect of, oh, well, it was just a clumsy choice of words. And I really just didn't want Trump people to get too excited if word got out about it. But if you actually read that email, I mean, and the testimony of people who were there that day, it really does not seem like that's what was going on at all. When
the sinner's deeds are judged by the Scandalakises, I don't know what the rest of that sentence is, but.
And look, I'm with Roger. I have always thought that a lot of these fake electors really did believe that they were doing something contingently. I don't know that the case against Burt Jones was a case that should have been brought. A grand jury did think so in the sense that the special grand jury recommended that he be indicted. But a grand jury will indict a ham sandwich, as the saying goes. I'm not sitting here saying, oh, Pete Scandalakis should have, indicted Burt Jones or recommended that he be indicted. But the way that this was written, it's very odd. It's very one-sided. It does not seem to give a complete picture of all of the facts. And then also, something else I'll mention too, I was in federal court in January when it was revealed through evidence in a voting systems case that Burt Jones is one of the people who called up a county elections officer trying to get access to machines for the Trump campaign to do a forensic audit. And there's nothing about that in this report whatsoever. There are things that just really, I think, were omitted here that does not give a lot of confidence to me, in Pete Scandalakis's, at least his report writing. I don't know what the extent of his investigation was, but then also keep in mind, if Fani Willis is disqualified, who is the person that will decide whether that case goes to another district attorney's office, or he might even decide himself what to do with it. So that it does not bode well for things if Fani Willis is disqualified.
All right. We got a lot of other ground to cover, so we're going to move on. Let's go through the other courts before we come back to the big New York Times story about three of our big cases. Roger, what's been going on in DC the last week and a half, 2 weeks?
Well, not much, but we are going to get a filing today. It probably won't be very important. This will be Trump's reply to you file a motion, the government responds, and then you file a reply. And so this motion sequence began last year, before the great disruption. And now we're back on track, and we had the motion and a response, and now finally we're getting the reply, and this is to a motion that he filed to compel discovery and to define the scope of the prosecution team. He wants to vastly expand the definition of prosecutor so he can get more discovery from lots of different federal agencies. I don't think this will work. He filed this also in version in front of Judge Cannon, and it seemed like it was going to work when the case was dismissed on other grounds. The thing we might get, the Judge Chutkan also asked that with this filing, there specifically be if Trump is going to claim that there's some discovery that relates to immunity that he doesn't have and should have, they should specify what it is. So that could possibly come tonight. The important thing will be a week from today. That will be the government's opening brief on the immunity questions, when they will not only put out their legal arguments about why they think the superseding indictment should pass muster, but they will also describe some other categories, they say, of non-pled evidence, stuff that isn't in the indictment, that also might implicate these new immunity issues. And so that could be new. It will certainly be new in this case. I don't know whether it'll be stuff we've never heard of, or it might be stuff we heard of during the January 6th committee hearings. But that should be pretty interesting. Another thing I've been wondering is if that's just a week away, that will be the first big deal filing since Chutkan got the case back.
Will it be 46 pages?
I think 48 was your guess. And I think with appendices, it might even be longer. But the thing I would ask, I would wonder about is if before then we might see, and this is just speculation, and somebody hasn't told me this is going to happen, if Trump's team might file a motion to request that any unpled evidence be filed under seal, or if he might also file before then a motion to unseal stuff before the grand jury that their team claims is exonerating of Trump. We heard at the hearing a couple weeks ago that they're claiming there is such evidence. So I'll be sort of surprised if it just plays out quietly and then we get a big 48-page filing on a week from tonight. But that's the big thing to be looking for.
Meanwhile, in Florida, the 11th Circuit briefing continues. What's the status of that?
It's on track. Trump asked for an extension and got one. Basically, his response to Jack Smith's appellate motion, this has to do, remember, that it was dismissed on the theory that he was not properly appointed under statutes. And so he filed his brief, a couple of amici filed on his behalf, and the Trump's brief was due September 25th. Now it's due October 25th. And actually, Jack Smith did not oppose that, but
he appears resigned at this stage to the idea that speed is A, not happening, and B, pissing off some of the justices.
Yeah, so the reply will come November 15th, and we'll see what happens. By then, we'll know who won the election, among other things.
And what about New York, Anna? What bring us up to speed on the sentencing that isn't happening in New York and the machinations around that?
Well, we still don't have, well, actually, I'm gonna leave it to Roger too, because I think that Roger has been keeping up with the ongoing appeals issues more than I have, and
All
then
right.
Ben,
In
come
that
back to
case,
me.
Roger.
For the Arizona stuff.
Okay, so where things stand now, you remember, I think you remember that Merchan did finally put off sentencing till November 16th, assuming it's still necessary after his immunity ruling. He put off the immunity ruling until November 12th. So both of those will be post-election. Meanwhile, remember he is trying to bring a second removal petition into federal court. That was denied by Judge Hellerstein, and then he appealed to the Second Circuit. He asked for an emergency administrative stay of Hellerstein's ruling, but after Justice Merchan put off the sentencing, the Second Circuit denied the emergency stay. There was no emergency. And so his appeal is due, Trump's appellate brief in the Second Circuit, that's the federal appellate court, will be October 14th.
And when are we expecting now the ruling from Justice Merchan about the application of the immunity decision? Has that been kicked back to?
Yeah. November 12th, also kicked back till after the election. No real explanation of that. I get, he explained that, he didn't want to do the sentencing till after the election because it might seem political. But and at the same time, he kicked that off too.
Maybe just wanted more time.
Conceivable. I don't know if it was smart, because that's going to leave 4 days between just 4 days between his ruling on immunity and the sentencing, which means a very compressed schedule if inevitably Trump tries interlocutory appeals before the sentence and put off the sentencing still further.
Right. Anna, do you have thoughts on the New York situation? All right. So let's move on to Arizona, which is still a relatively new addition to our Trump Trials and Tribulations docket. Anna, remind us what's going on in Arizona and bring us up to speed.
Yeah, so keep in mind that Mark Meadows has been indicted there for interfering in the election in 2020. And he, including along with other folks who have been indicted in other places, including Georgia. And he has sought to, as he did in Georgia, similarly there sought to remove his state crimes to federal court. That was rejected in Georgia first by Judge Steve Jones, then it went to the 11th Circuit. The 11th Circuit also agreed that Mark Meadows should not be able to remove his charges to a federal forum. Now that is pending before the Supreme Court. But Meadows was then later indicted in Arizona. You typically have 30 days after arraignment in a state case to try to remove your case to a federal forum. Meadows missed that deadline by about 18 days. We spoke about this, I believe it was on the last Trump Trials and Tribulations, in which someone had a question about it. And he nonetheless tried to file to remove belatedly. There was briefing over the matter. As Trump Trials and Tribulations listeners might recall, the key issue whenever you're trying to remove a case from state to federal court is this question of whether you were a federal officer, and are you being indicted for conduct that relates to the duties of your federal office. So here the court released an order, the federal court did, denying Meadows' attempts to move his case to federal court. The court said, A, you were late, and I don't think that there's a good excuse for you being late. And so, there's that. You can't remove for that reason. But then also, B, I find that you are not being prosecuted. There's no causal nexus. That's the term that was used here between the allegations in the indictment and then your federal office. The main theory that Meadows raised here was similar to what he raised in Georgia, where he was saying, oh, I've been indicted for things like calls and texts and doing these things that were more like secretarial duties on behalf of the president. And the court said here, no, that you weren't, the allegations in the indictment here don't relate to things that are just merely secretarial duties. You're not being prosecuted for that. You're being prosecuted for illegal electioneering. I'm curious what Roger thought about this order, because it was very much in line with the district court's order in the Georgia case. It did not reach the question that the 11th Circuit reached, which was that kind of controversial point that we've discussed, which is the 11th Circuit decided that former federal officials like Meadows, only current federal officials cannot remove their cases to federal court. But I still just wonder how, Roger, I'm curious how you think this dovetails at all with the way the Supreme Court decided the presidential immunity case, because there's very different things going on here, but it will be very interesting whenever Meadows, Georgia case, supremacy clause removal case potentially goes to the Supreme Court, because there's a lot of questions here about scope of office that were also raised in the presidential immunity case. And so it makes for interesting kind of analysis in terms of how those two things might match up.
Yeah, these, the filing late aspect of it is such an easy thing that, and filing by 18 days late, it's not like, you got mixed up or you didn't know, you thought business days instead of calendar days or something. I mean, and it's so strange since he had already, the same lawyer had handled one of these, and he had filed, I think he filed the Meadows removal petition 2 days after arraignment in Georgia. So something like that. So that's sort of the easy part. The other parts of these removal petitions are really opaque to me. The standard for or relating to any act under color of such office, and then you're trying to do this before the case has been tried, so you hold a little evidentiary hearing, and so I don't know. I really can't apply the federal immunity rule, Supreme Court immunity ruling to this one. I can't even very confidently compare this removal petition to the Georgia one, because although I assume the allegations are the same and the two similar, I didn't study them, and they didn't. It sounded like the pleading in Arizona made a stronger case, in certain respects. Certainly the language allegedly orchestrating and participating in an illegal electioneering scheme sounds a lot different from, calling somebody on behalf of the president, which is what some of the overt acts in Georgia were, which is a lot like a gatekeeper function. I guess the other thing about that is really just perplexing to me about the the duties of a chief of staff of the president. Your official duties involve unofficial acts. You're allowed as chief of staff to do campaign activities for the president. It's not like you're, doing a second job. That's part of so the unofficial act is a part of the official. So that's just, I don't know I don't know how to unravel those questions.
All right. We are going to go to audience questions shortly, but we have to do two things before we do. Three things. The first thing is I have to remind you to get your questions in by the top of the hour, at which point, a mere 12 minutes from now, the Q&A will seal off and new questions will not be admitted. The second thing is to remind you that next week, there may be no Trump trials and tribulations. There may be, but there will certainly be on Tuesday at 1:30 p.m., the second in our installment of Lawfare elections coverage, Lawfare Live elections coverage. Will we be talking about the polls? No. Will we be talking about who's up, who's down? No. We will be talking about the mechanics of contested elections this time around versus 4 years ago. How are things similar at the federal level? How are they different? How are they similar at the state level in the executive branches? How are they different and similar in state legislative matters? We got a great bunch of people to talk about it. It's going to be super informative. And I promise you, if the election is close, and if stuff is getting ugly, you will be glad to know what the state of affairs was from Lawfare Live. So that's Tuesday, 1:30 p.m. I'll be doing it from some student room at the Harvard Law School where I will be giving a talk. And we have a great bunch of people. So join us. The final thing before I move on is I just want you all to remember that you should become material supporters of Lawfare. And you can do that at lawfaremedia.org/support. You can join the inner sanctum of people who get their questions answered. Somebody named Anonymous Attendee has 3 questions up in the queue right now. We're going to get them all. I don't know if that's 1 person, 2 person, or 3 people. You can be like Anonymous Attendee and get your questions answered, become a material supporter of Lawfare. Somebody in the chat points out that Anonymous Attendee could even be a dog, and that's correct. All right. There was a story in the New York Times the other day, and it was kind of a Lawfare whopper. It was about how the Chief Justice of the United States had been the hidden hand. It wasn't that hidden, seeing as how he wrote all 3 opinions, behind the immunity case, the Fisher case, and the Trump disqualification case, Colorado v. Trump, or Trump v. Colorado, and that in fact Roberts had not been the consensus building moderate, but in fact the driving force behind these 3 opinions, which cumulatively amounted to a great win for the former president. I'm just going to start with Roger, your thoughts, Anna, your thoughts, and then I will give my thoughts. What did you make of it, Roger?
Well, it was it had a lot of fascinating little things. It was called How Robert Shaped Trump's Supreme Court Winning Streak. It's by Jody Cantor and Adam Liptak. Liptak, of course, is the longtime Supreme Court reporter. Jody Cantor is not, which is sort of, I mean, she's a top reporter, but not usually about the Supreme Court. I think it's pretty obvious, becomes obvious why she's involved. But you know,
You should explain that.
well,
I agree.
One of the interesting tidbits is about the, I think the Fisher ruling, which Roberts assigned to Samuel Fisher, of course, is the ruling about corrupt obstruction of an official proceeding, 18 USC 1512 C2, greatly narrowing this important statute in the January 6th cases, and also one of the two of the counts against Trump in DC really revolve around that. And he in that case, it reveals that he originally assigned the ruling, the opinion writing to Alito in April, and then in May he de-assigned it and took from Alito and took it himself on May 20th. And the switch came 4 days after a New York Times article by Jody Cantor about how a upside down U.S. flag had been flying over the Alito household in Alexandria, Virginia, after the January 6th insurrection and up to the inauguration. That was a Stop the Steal emblematic flag, and apparently Mrs. Alito liked to fly it. And 4 days after that article, apparently he reassigned the case. So I total speculation, but I imagine one of the leakers might have gone to Cantor and revealed some of this. But if there was a unifying theory to the article, and maybe there wasn't, I think it was that the benighted recurring belief of the conservatives generally and of Roberts in particular, that he could, his soaring rhetoric would captivate the American public, and they would all realize that he was acting apolitically and in the country's best interest. And I think it's this recurring thing where the Republican appointees on the court think that rulings that happen to benefit Republicans are apolitical, and rulings that happen to benefit Democrats are political. But in any event, all three of these cases, we saw that phenomenon playing out. There's lots of interesting details. I can go into some of them, but maybe I should just cede my time and let other people chat.
Anna, what were your thoughts?
Well, look, I think that one of my big interests here is how there has been a big shift in media coverage of the court, in the sense that people are actually covering the court in basically real. I mean, look, we've always had books that years and years after the fact, we'll talk about some of the horse trading between the justices. We'll talk about things that were going on at the court, but it'll be, I mean, like years after the fact. What's been really interesting is that we've seen examples more recently of the court, you know, relatively contemporaneous reporting on what is happening in cases that just were released. To add to Roger's conversation about Jody Cantor, for those who don't know who Jodi Kantor is or what she's reported on, she is a reporter who did a lot of reporting on Me Too issues. She, in December of 2023, before she wrote that Alito flag story, she did another story with Adam Liptak in which it was very similar in that it was an investigative report about how the Dobbs decision came to be, and also drew on a lot of things like internal memoranda within the court, letters passed between the justices. So to be honest with you, I substantively, I agree with Roger's points and all of that. But I just, my own kind of pet project here or interest is this idea that there has been an increased way of or investigative kind of posture towards the court and the way that it institutionally is composed and decides and makes decisions. So I don't know if that's worth delving into more, but that was kind of one of my key takeaways in addition to the other kind of substantive things that Roger talked about.
So I have a couple things to add. First, on the journalism side of it, it bears a striking resemblance to Politico's breaking of the story of the Dobbs draft, where somebody who is not a court reporter seems to get the leak, brings it to, in the case of Politico, it was one of their national security reporters brings the story to a veteran court reporter, in Politico's case, Josh Gerstein, and they do it together. Here you have, I think Roger's almost certainly correct, that the story comes through Jodi Kantor because of her work on the Alitos, and brings it to Adam Liptak, who has the court depth to kind of fill it out. So I do think it's a weird kind of story that we didn't used to see, but somebody who's not a court reporter getting court dirt basically and bringing it to court reporters, and then they team up to do these stories.
But hold on, I want to make it clear though that Jodi Kantor has written on the Supreme Court. I don't think it's as unusual.
Jodi Kantor is a first-rate investigative reporter.
Yeah, I don't think it's as unusual as the Politico situation, but I take the point. I think that this is a little bit different in that it seems like Jodi Kantor has been working sources on the court for months now.
About the Alito situation.
Well, there's also, I mentioned the Dobbs story that they wrote as well, which
yeah, that's a good point.
The lead on that story was about, she obviously has Alito sources because the lead in that story is what was going on with Samuel Alito with the Dobbs opinion. So it's very interesting trying to trace what's going on here with the sourcing, but I do think it's a little bit different from the Dobbs thing.
Yeah, it's a very good point. Jodi Kantor is far less out of left field on this than the byline in the Dobbs, which actually I can't even remember what his name was. It was Alex. It'll come to me. So
Alex Ward,
right. So the second thing is this falls into a very long line, assuming this reporting is accurate, of Supreme Court justices thinking they can create compromises for which a grateful nation will thank them and think of them as statesmanlike. And of course, a lot of these turn out to be disasters. Trying to bridge the Great Divide was actually what was behind the Dred Scott decision, right? And the sense that the Supreme Court, the adults, need to step in and sort of settle the chasms of dispute between the mere mortals that have to live in the country. And one thing that you were not selected for when you are selected to be a Supreme Court justice is political wisdom. And, you know, if it is true that Roberts thought he was, you know, bridging the gap here and creating a workable system that the people could live with, I'm like, that is just rank foolishness on his part. And I have to hope that the story is ungenerous in that regard, or erroneous in that regard, but I fear it is not. And I do think believing that you're capable of kind of uh believing that you're capable of regulating the political branches and creating compromise is one of the hazards of the position. And I do fear that that may be part of the explanation for what happened here. And if so, it is very unflattering to Roberts. I will also say that it is unflattering to, you know, one of the most cringy parts of the story is when Brett Kavanaugh and Neil Gorsuch start profusely thanking him for the quality of this work, which has been received as of such low quality outside the court, including by people who are not ideologically unsympathetic. And so I just think there's a lot of material in here about how quickly you get Howe out of touch when you sit up there. All right, let us go to questions. We have 7 of them. We are going to get through them all. Devin Nunez's lawyer asks, what is Mark Meadows' current situation? It seems like we heard he might be cooperating, but I feel like we've lost track of him. What do we know about Mark Meadows' cooperation, guys?
I'm going to defer to Anna on that.
Well, we know that he got some form of immunity in the federal cases. He was not indicted in the federal cases, and it seems like a big reason for that is obviously because of his cooperation. But then he was indicted in Georgia, in Arizona. Am I missing anywhere, Roger? I don't think so. I think it's just Georgia and Arizona. And a part of his argument in Georgia, when he's been trying to make, you know, his supremacy clause argument, this is all before the case was put on pause. He's one of the defendants who is litigating the appeal to disqualify Fani Willis. One of the arguments was that, you know, well, the feds didn't see fit to indict me. And if I could just get all of this information that they have to show you why they didn't indict me, then you'd see that I never should have been indicted. You know, if we were back in January and it was before Ashley Merchant filed the motion to disqualify, I would have told you that I think that if Fani Willis was willing to make a deal, which I think eventually she would have been, I would have thought that Mark Meadows might eventually, as we got closer to trial, made a deal, pleaded out. But things have substantially changed in that case in terms of the balance of power and the leverage that the prosecution versus the defense has and that kind of thing. So I come back to me in a few months when the Georgia Court of Appeals decides, and then we can discuss. But I think right now, I don't know about the Arizona case because that case, I believe, is scheduled to go to trial in January. Is that right? Still right, Roger? Okay. I think that case is scheduled for January. So we'll see what happens then. Ben, do you have thoughts about what you think Meadows might do if it's eve of trial? I feel like maybe a plea, but I don't know.
I mean, I think you have to know a bit about his financial situation to know the answer to that. It is always advantageous when the evidence it implicates you not to go to trial. But the psychology of different defendants is different, and the psychology and the advice they get from counsel is different, and their financial capacity to handle a trial which can be protracted is different. And so I have always expected Meadows to plead out, but it hasn't happened. And so who knows? All right, the anonymous attendee, question number 1. We've seen some spectacular leaks from the Supreme Court in the last few years. For example, Dobbs, the sourcing for this New York Times story, etc. How unusual are these, and what, if anything, does it tell us about the court and how things run there? So we've sort of covered this question, but I will just say it's quite different from what it used to be, only recently. When it used to be unheard of. That began to change in the 1976 book, The Brethren, when Bob Woodward and I think, I can't remember who his co-author was on The Brethren, actually clearly did talk to some justices, talk to some clerks. That was a scandalous thing then. And now it is a mildly scandalous thing, the Dobbs leak was investigated, but never successfully and never with any hope of getting it. And I think it's identifying the person. I think we just have to assume that the court is, like every other institution, only as capable of keeping its secrets as its own people are invested in its integrity. I don't know. Do either of you have stuff to add to that?
Not really. I think there had been a the outcome of Roe versus Wade was leaked a few minutes or hours before it came out, something like that, just the outcome. But these things are really unbelievable. I mean, it really has to be not just clerks, but the justices themselves who are now, dishing on each other. And I think it just shows how angry they are at each other, and how much they distrust each other. And this court has lost its aura. It's lost legitimacy. And that's why earlier today I spoke about the Republican appointees. We usually go through, we say, the conservative appointees or justices or those with a conservative jurisprudence. But when it's 6-3 and the 6 Republican appointees are benefiting the Republican candidate, and it's not once, it's a repeated pattern. It's not 6-3 every time, that's true, but there is a pattern. And you just begin to feel like, look, if they aren't going to try to protect their legitimacy, why should I? We see what's happening. If they want to try to strive for legitimacy again, let them. But we don't see it right now.
So I will say that I am in total agreement that this is not a reflection of reporters doing something different and successfully. This is a reflection of the people who are at the court doing something different because it is a symptom of the justices being in all-out war with each other. But like, and Roger and Ben, curious if you disagree, but that knowing people who go on to, clerk at the district court and the appeals court and the Supreme Court, these are not the type of people who are going out and leaking to reporters. The clerks got there because they are good at not going and talking to people about things. They are rule followers to the extreme. And so people a lot of times, I think, reading these stories have recently been saying, oh, I wonder whose clerks are talking or which clerk leaked the draft opinion. I mean, look, this is total speculation, but my view is, as Roger said, this is not happening unless it is the justices are somehow tacitly or explicitly consenting to people talking about this kind of stuff. And maybe I'm wrong about that. I don't know. But I think that it has to be the case that there is something different about what the justices themselves are doing as opposed to what reporters or people who are around the court are doing. And it's a crisis within the court itself, but it is one that the justices have made and are a part of, I think.
All right. Anonymous attendee question 2. Not sure if this question is too political for the forum, but if hypothetically I were canvassing for a Democratic candidate this upcoming weekend, and a potential voter accused the party of, quote, waging lawfare, unquote, against President Trump, what is the best response to get them to take the trials and tribulations seriously, or is it a lost cause? Well, I will say first of all, that absolutely is too political a question for this forum. And I am not going to give you advice about what to say while politically canvassing on behalf of any candidate, this being a 501c3 organization that does not endorse candidates, does not canvass for candidates, and does not provide argumentation for people. I will say that whenever anybody in a canvassing environment or not mentions somebody waging lawfare against somebody else, the proper response is to remind them that there is this site called Lawfare, which is available at lawfaremedia.org, where you can wage lawfare all you want and learn about Trump's trials and tribulations and other matters.
But maybe you should add a note on the origin of the word lawfare, which predates all of this.
Yes, the word lawfare actually dates, believe it or not, it is commonly thought to be a coinage of a former JAG, who now teaches at Duke. That is actually a myth. He was something of a popularizer of the term, but the term actually dates from the 1970s and has had a fascinating and a bit tortured history, and you can read about it on the About page of the site. The anonymous attendee in his, her, or their third question asks, the Trump versus United States ruling was a surprise to many of us. What additional surprises did you encounter reading the New York Times story? Do you feel at all that your prior views of Roberts were off, and if so, by how much? Is there a new understanding of the sorts of arguments Roberts is likely to entertain, and what would they look like? So I can only answer that for myself. And I'm, the part that surprised me was the sycophantic reaction among some of the justices to what Roberts did. I am biased in this question by having known John Roberts for, more than 20 years or 20 years or so. I certainly did not expect this opinion of him. I was not at all surprised by Fisher, which I think I said to Roger early in the Fisher litigation when it was splitting the district court, that this is exactly the kind of argument that will appeal to justices like Roberts, who have a general suspicion of broadly worded federal criminal statutes in white collar cases. So I think Fisher is perfectly consistent with the direction that he's been quite consistent about. This one took me completely by surprise. And does that reflect that I had him wrong, or does it reflect that he's evolved over the years and acquired a kind of grandiosity that he didn't used to have? I don't know, and I don't honestly trust myself to judge that. I did find the oral argument surprising, and the tone of him at the oral argument really surprised me. And then the decision, even despite the oral argument, surprised me. So, like, I was in a predictive sense wrong about every component of this. So I'm not exactly sure what lesson to take from it. Roger, Anna, what was your thought?
I was completely blindsided by the opinion. I did know that Roberts is more conservative than I usually think. I sort of know that intellectually, but I did think of him as caring about the court's legitimacy. It was just, my whole life has been, if you had asked me in elementary school, what does the country stand for? I would have said, all men are created equal and no man is above the law. And then, when I'm 18, the Nixon versus United States comes down, and I am, it's 8-0, and the whole court agrees that, no man is above the law. That's basically the ruling in a nutshell. And that frames my view of the Supreme Court until 10:30 a.m. July 1st. And then I find out, no, not everyone is above the law, or there's all these asterisks, or, there's 3 categories, or, and we didn't really mean it. And I mean, those people who have been listening to us know how wrong I was about this right up until that time, and how all the clues were there. But but this has been an earth-shaking experience, for me personally.
I mean, yeah, but look, we should have known, honestly, after the Anderson opinion, not because of the outcome of Anderson, but because of just how intellectually, it was just, just bad writing, bad lawyering. I don't know why I was as surprised as I was, but yeah, I was surprised. But also maybe we shouldn't have been surprised when you give 9 philosopher kings a position for life and they can do whatever they want. It is not surprising that there is a disconnect between maybe what they think is the kind of politically neutral way of coming out on an opinion versus what most people would think. But yeah.
All right. Penelope asks, Roger, it sounded to me as if you agree that electioneering is part of official duties. With Meadows, which blows all cases and counts against not only Meadows, but also Trump. Could you explain that position more fully without giving more ammunition to Meadows? Wait, you're muted, Roger.
I think it's only Meadows. It just happens to be like, and maybe I'm wrong, but if you look at like the Hatch Act, you know, there's a lot of people that aren't supposed to do this stuff. I think the chief of staff is an exception of the president. He's allowed to do it. You know, it's part of his job. It's not part of it's not part of the president's job as an official act. You know, it's not an official act of the presidency, but part of this chief of staff job is this gatekeeper role, and you're sort of the gopher of the president, and that includes go get me this, go get me that, go get me my coffee, and talk to the campaign people, and so for him, doing campaign stuff sort of is the job. So I don't know if and we're using these words, you know, these words mean potentially one thing in the context of a removal statute, where we're just talking about federal officers, what's their duty, and another in the context of the president, what is for presidential immunity, what is an official act for purposes of absolute immunity. I think those are different things. But so I think it's a peculiarity of the chief of staff. I don't think it's generalizable.
I mean, just to foot stomp Roger's point, I think a lot of the time the chief of staff might not even know which role he's playing, right? The president says, you know, we need to talk to so-and-so, you know, organize a meeting with this group of people. It's not necessarily, I mean, the chief of staff knows as much as the president wants him to know. All right, last question from Josh. Any news about the civil trials and tribulations, the two E. Jean Carroll cases and the New York civil fraud case? I have no information new about these cases. Do either of you?
I have a little. E. Jean Carroll 2 was argued in the Second Circuit. The Trump's brief in E. G. Carroll 1 was filed in the Second Circuit, his opening brief. He asked for an extension and did not get it. The argument was interesting. He got sort of what I think most people would consider a favorable panel. It was a panel of three judges, 2 women and 3 Democrats. But there are some questions of first impression in that case, which have to do with it all revolved around the use of the evidence of similar acts with other women, particularly Natasha Stoynoff, the People reporter in around 2005, and the Jessica Leeds incident. She was the woman on the airplane in about 1979 that he allegedly groped. And so this gets into a tricky area about when you can use bad acts that aren't the subject of a particular suit. And Congress actually changed that law a few years ago. I don't know if it was literally the Me Too era, but it was something similar. And they allowed a special case in the case of sexual assault evidence. And so there's technical issues about whether these other allegations, which of course Trump denies, that Jessica Lee's was that sexual assault within the meaning of this statute. And, you know, it gets onto, well, it was an airplane. And so what's the jurisdiction over the airplane and what were the laws on that in 1979? But I think they were also considering the harmless error angle on this, that does this really matter? Was there ample evidence without this? Anyway, it was an interesting argument. I don't know where the civil fraud case stands.
We are going to leave it there. Hey, folks, if you are in the YouTube, come into the inner circle. I beckon you. lawfaremedia.org/support. We will see you next time.